For well over 1,000 years, Ireland operated under a legal system unlike anything else in medieval Europe. While most of the continent moved toward feudal, centralized power, invariably with a powerful monarch, Ireland did not. This lack of a centralized state meant that Irish legal practices moved in a very different direction. Known as Brehon law, this native Gaelic tradition governed Irish society from the early medieval period. It lasted until its suppression under English rule in the early 17th century. Far from being primitive or informal, Brehon law was a sophisticated legal system. It was administered by a professional class of judges. It was preserved in an extensive body of written texts. Its principles would seem strange to us today. It prioritized status, family relationships, and restitution over punishment. The judges administering the system formed a hereditary learned class. They held a social position similar to bards, poets, and doctors, and to other trained specialists of the time. Legal knowledge passed down through families and years of formal training. Apprentice judges spent years mastering the law before they could interpret or apply it. It is important to understand that these figures were not judges in the modern sense of the word. They were not state officials overseeing formal trials, where guilt or innocence was decided on the basis of evidence. They were not supported by a legal administration or police force. There was no centralized court system. Rather, these judges worked more like arbitrators. Their authority rested on their learning and their reputation. These judges handled a wide range of everyday disputes. Common cases involved land boundaries, livestock trespass, unpaid debts, contracts, and personal injury. Judgments drew on an extensive body of precedent and legal formula, built up over generations and set down in the written law tracts. A judge would hear both sides of a dispute, weigh the rank and honor price of everyone involved, and set the appropriate compensation. Guarantors, trusted figures who pledged to ensure a ruling was honored, were often brought in to back up the outcome. If compensation was refused or could not be paid, a dispute could escalate into violence. Even so, the strong preference was for negotiated restitution. This compensation-based approach extended even to homicide. Rather than execution or imprisonment, the offender's family paid compensation directly to the victim's family. That figure was known as the honor price, the standard translation of an old Irish term sometimes rendered as the price of one's face. Many legal judgments, though not all, centered on it. Every free person in Gaelic society had an honor price, set according to social rank, profession, and standing. It also affected a person's legal standing as a witness or guarantor. A king's honor price vastly exceeded that of a commoner. Skilled professionals, such as poets and physicians, held disproportionately high honor prices, reflecting the value Gaelic society placed on learning and craft. Similar graded compensation systems existed elsewhere in early medieval Europe. The Irish version stands out for its detail and for the sheer volume of surviving texts. Society was broadly divided into nobles, freemen, and various categories of unfree or semi-free persons. Freemen included farmers and the professional classes already mentioned, some of whom were treated as nobility in their own right, regardless of birth or land. Family structures were central to how the law functioned. The extended family group bore collective responsibility for the actions and debts of its members. If a person could not pay compensation for an offense, their family could be called upon to make up the difference. This gave families a strong incentive to police the behaviour of their own members. Brehon law is also notable for the rights it gave women, compared with English common law or other European legal systems operating during the medieval period. There was a detailed body of law that dealt specifically with marriage. It catalogued several distinct categories of union, reflecting a nuanced approach to relationships and their legal consequences. Women could hold and control certain forms of property. Divorce was permitted under defined circumstances, with detailed rules on how property would be divided. Nevertheless, Gaelic society remained patriarchal in most respects. Land inheritance, for example, was heavily restricted for women. Brehon law did not disappear overnight. For centuries after the Anglo-Norman invasion of 1169, it coexisted uneasily alongside English common law. Gaelic lordships kept operating under native legal custom even as English authority expanded around them. English administrators frequently criticized Brehon law as barbarous, partly to justify further conquest. The system's effective end came with the collapse of the Gaelic order itself. The Tudor conquest of Ireland steadily eroded Gaelic society throughout the 16th century. Then, In 1607, the flight of the Earls saw the last major Gaelic lords flee Ulster for the continent. This removed the final patronage networks that had kept native law functioning. English common law was then formally extended across the island. Brehon law faded from active use. It survived only in the manuscripts that later scholars would painstakingly recover and translate. Much of what we know today comes from 19th century scholarship. The primary contribution came from two Irish academics, John O'Donovan and Eugene O'Curry, who transcribed and translated the surviving legal manuscripts. Their work produced a series of volumes titled The Ancient Laws of Ireland. This written record tells us of an alternative legal philosophy that prioritized restitution over retribution, honor over hierarchy of force, and the maintenance of social relationships over the punitive power of a centralized state.